1970, New Delhi. A boy aged 15 and a half from the district town of Dibrugarh in northeastern Assam arrived in India's capital to study at Delhi University. He was in for a shock. He was told he could not be admitted as he was underaged. The teenager persisted, finally secured a relaxation in the age guideline and joined St. Stephen's College, from where he graduated. After 8 years in the national capital, the youth returned to Assam with a law degree. He spent long hours in the study table, burning the midnight oil, and achieved a degree of success in the legal profession, which led to his elevation as a High Court judge at a relatively young age of 46. This was followed by appointment as Chief Justice of the Punjab and Haryana High Court in Chandigarh. Very soon, he retraced his steps back to the national capital to serve as the judge of the Supreme Court of India and subsequently as its 46th Chief Justice, end quotation. Ladies and gentlemen, I took the liberty of introducing our next speaker and our chief guest. In his own words, these lines, the quoted lines, gives us a glimpse into this illustrious life of our chief guest. These lines are featured in the opening paragraph of Sir's autobiography, Justice for the Judge. With immense honor and profound privilege, may I request our chief guest, Honorable Justice Shri Ranjan Gogoi, to deliver the inaugural address.
A very good morning to everybody present. Dr. Ansari, the Chancellor, thank you for inviting me. Shri Modi, the Vice Chancellor, Professor Singh, thank you for your kind words. Professor Chaudhary of the Tejpur University, I have not met you, I have heard about you, a great contributor. My old friend and acquaintance, Borpatragohain, the former Advocate General, Mrs. Fukan, the former judge, Madam Borua, Dr. Bhuvan Borua, and the last, my brother-in-law, Dr. Buragohain. All other speakers have maintained their time. I will try and do that. My address is primarily for the law students. To the students beyond law and to the faculty members. First, let me compliment the law students on their choice of their field of study and the institution. I've seen very little of this. I've been promised to be a visit around at the end of the event. It looks like a very good place to study. What I have said is an excellent field of academic work, law. Law gives you many options. It could give you an excellent career in teaching law. You can't have lawyers, you can't have corporates without good law teachers. And universities like Royal Global, Aziz Premji, NLUs all over the country, they encourage young people to come and teach law. Some of you could become corporates, join law firms. Some of you could join companies, become their general counsels, and some of you could go and practice law. Now, I must find a common ground or a common point where after you pass out and join any of these diverse fields, there must be a common point which I must find to address you. That will be my attempt and endeavor. Now, there is a popular saying, and I agree with it. The law takes you backwards. The law takes you into the past. And I don't believe in the past. I have little faith in the present. And I have immense trust in the future, that is you. But law takes you to the past. How? Now, if you strike upon a proposition in law, the first thing you look for is a precedent. Somebody 100 years back thought similarly. You try and find AIR 27 Rangoon or Oudh, one of these high courts, to sustain the point. Why should you? It's a step backward, and at times a giant step backwards. Look at the laws, the primary laws in this country. The Penal Code is of 1860. The Evidence Act is of 1872. The CPC, with amendments, of course, is of 1908. The CRPC, similarly, is a century old. Of course, bills to bring about reforms or changes in these three primary laws is pending before Parliament. Some of it is good, some of it is bad. Mr. Pansari, the issue that you raised about FIRs perhaps is being dealt with in the amendment. There are some positive things in the amendments, but we will not discuss it because it is before Parliament. Let the Parliament discuss it. Now, these are all steps or a journey into the future, to the past, whereas the journey should be to the future. Law moves behind. You should be moving ahead. Now, what moves ahead? Science, technology is that it moves ahead. So we must try and strike a relationship between science, law, and technology. Otherwise, law will become irrelevant. This is my sincere belief. And it is to tell you about this that I have come all the way to this great institution. Now let me tell you something about law and technology, and in doing so, I will confine myself to the basic law, not to what the high courts and the Supreme Courts are doing in the area of public law, whether they're encroaching into governance or whether the governance is failing. We'll not go into all those controversial areas. We'll deal with some basic laws. You know, one problem in this country which we faced recently is the one relating to sentencing. When you find a person guilty of an offense, you sentence him. Look at the Indian Penal Code, the language used. Not less than 7 years. but may extend to. Elsewhere you will find may extend to 5 years, may extend to 2 years, may extend to 10 years. Now, how does the judge decide what should be the sentence? The person who has been convicted would like his sentence to be decided on certain objective parameters. What are these objective parameters today? None. Now, in certain more developed areas of jurisprudence, you have what is known as the compass. Now, this is not a mariner's compass. COMPAS, compass. And what does compass fully stand for? Correctional Offender Management Profiling for Alternative Sanction. It is a tool to assess or calculate the likelihood of the offender committing the same offense or any other offense. What in legal terms is known as recidivism. Now, this formula, this mathematical tool, has got certain components. Number one, the age of the convict. Number two, the age when he committed the first offense, the likelihood of him committing the offense again, the history of violence, etc., etc. And these are all fed into the system, and the system comes up with the result as to what should be the appropriate measure of punishment. Now, this has the approval of the US Supreme Court. This mechanism was put to challenge before the US Supreme Court. The Supreme Court said, no, it's fine. The parameters are okay. You don't have that in India. As a result, today, you are struggling with sentencing. Now, science is an art of making complicated things easy. Law is an art of making easy things complicated. Look at the festival, Lex Fiesta. Mr. Pansari, not too many people outside the realm of law will understand what is Lex Fiesta. Lex is a Greek word. Fiesta is a Spanish word. Why couldn't you have a law festival? You made it complicated. I'll tell you about the famous story of that orange. Some of you may have heard it. You know, when I give you an orange, what do I say? I give you an orange. You know what a lawyer will say? I will tell you. I will say, here is an orange, please take it. Now, what is taught in the law schools and what the lawyer will say is something like this. I hereby give you and convey to you, all and singular, my estate and interests, rights, claims, title, claims and advantages in the said orange, together with all its rind, juice, pulp, and seeds, and all rights and advantages with full power to bite, cut, freeze, and otherwise eat the same, or give away the same with and without the pulp, juice, and seeds, anything herein before or herein after, or in any deed or deeds, instruments, so on and so forth. This is how a lawyer will say, I give you an orange. Now, I don't want you to learn this law. Don't learn it, please. Don't learn it. We have learnt it. I don't want you to learn it. Now, the American Bar Association, they have a section for science and technology. Do we have it in India? No. What do we have in India? We have PILs, public interest litigations, touching matters that shouldn't concern the judiciary. Science and technology, no. The American Bar Association has it. And what does it do? It does research in areas like cybercrime, genetic researches, biotechnology, nanotechnology. This is what they do. And they also have a national conference of lawyers and scientists consisting of 14 members, where a better understanding of science is conveyed to the lawyers, and a better understanding of the legal system is conveyed to the scientists. You know, one area of great interest that these two forums in America is doing is studying the relation between neurosciences and law. Now, what does neurosciences have to do with law? You know, tomorrow when some of you become lawyers or some of you become corporate executives advising the companies on their legal rights, you will be dealing with evidence. We have a very elaborate Indian Evidence Act. What is evidence? Evidence is a narration by a person from his memory. What is memory? You know, the brain, the human brain, is so complex that it has not been able to understand itself. Its power of storage, retrieval, to forget is immense. I give you a simple example. There are certain things that we never forget, and certain things that we easily forget. Your car keys, where have you kept it? You forget. To drive the vehicle or to swim, you don't forget. Why? This is what neuroscience does. Memories can be illusory. Memories can be planted. And what would happen? These have been demonstrated scientifically by psychologists. What would happen to the evidence that is planted or based on planted memory? What would happen to evidence which is based on illusory memory? Now, this is a field of study. What would happen to the core of any case if the evidence is faulty? And it can be faulty. It has been demonstrated. I give you an example. A 13-year-old boy was made to believe that when he was 4 years old, he had a very unpleasant experience when he had visited the mall. And he kept on repeating until the psychologist demonstrated and admitted that he had planted this story, and it was so well stored in the memory that the boy, when he grew up, believed that it is the correct fact. How dangerous it can be. And as a lawyer, how challenging would be your task to find out if the deposition or the evidence given by a witness is planted or illusory. This is the state of law in the future. I give you another example. There was this 13-year-old boy who, on a confession made by him, admitted to have committed a sexual offense against a 17-year-old girl. He admitted it, he confessed, and he was convicted. 13 years later, while one person was undergoing a DNA test, he confessed to that crime. That boy was innocent. But he was made to believe that he had committed that offense. This is the state of memory. And neurosciences help study the state of the memory, the genuineness of the memory, so that the evidence that is being given in court is based on acceptable memory and not illusory or planted memory. There are challenges coming. There was this gentleman who had a very severe headache. And while having this headache, he committed certain crimes. He was convicted, taken to jail. For his headache, he was operated. There was a tumor. They removed the tumor. And once the tumor was removed, he was absolutely normal. He was one of the best inmates of the prison. So they sent him on probation to his home. At home, he again developed this headache. He again started misbehaving and committing crimes. So he was again taken to the hospital. They found the tumor has regrown. And they removed the tumor. He became normal again. Now the question that I ask, not myself, ask you. This time it is you who will answer. Who's responsible? Is the man responsible for the crime, or is the tumor responsible for the crime? What is the state of the law? Does the tumor amount to temporary insanity, which could be a defense in criminal law? These are the questions that are coming up, and you have to be ready with it. And I tell you why you have to be ready with it shortly. This area of human reproduction is another very, very emerging area. How many of you, and I'm asking the students, have heard of this expression, savior siblings? Savior, S-A-V-I-O-R, savior, to save siblings. The first savior sibling in India was born in 2020. What is a savior sibling? A young child has serious medical issues, blood disorder, cancer. He won't survive. The parents decide to go for IFV. And before implanting the embryo, certain cells are adjusted, removed or put. And once the baby is born, from the umbilical cord, the stem cells are taken and injected into the diseased sibling. The diseased sibling becomes healthy. So this baby is known as savior. In India, it has started. Where is the law? No. Where is the regulatory framework? No framework. Who decides these very, very weighty questions? These matters are coming to court. This is not futuristic. It is reality coming, staring at us. Do you know that a research by a financial institution had found that a pilotless plane, aircraft, is safer than a plane being piloted by humans. 80% of the plane crashes are on account of human errors, pilot fatigue, pilotless airplanes. It is going to save $200 billion every year. Think of this money which can go elsewhere. If there can be pilotless planes, there can be driverless cars. What about motor accidents, claims for driverless accidents caused by driverless cars? I can go on multiplying the challenges that are coming. Now, how quickly these challenges would come is for something that you have to work out. You know, when I started my legal practice a few years after I started in the 80s, early 80s, I had to struggle for a landline connection, a telephone connection. 2007, we had the iPhones, the Android phones. And today, this is not a cell phone. This is not a cell phone. This is a supercomputer. We use only 1% of it. It is endless and limitless. So in 40 years, from a landline, I have a supercomputer. I take it that you are good for the next 50 years, because I am 70. If I am good till 70, you are good for the next 50 years. 50 years is staring at you. Legal education must go away from the conventional education and make you fit, you and your next generation of students fit to meet these challenges that are coming. They may come much before 50 years. I don't know. Maybe in a decade or two, but you have to be prepared. And the system and this institution in the coming years have to make the younger generation ready for these challenges. This is how humanity can survive, the nation can prosper. I don't think I would like to say anything further. I have to thank two persons for the inputs that I have used in this address. One is my dear friend, a retired judge of the Supreme Court, Justice Rama Subramaniam. If you permit me, I'll bring him here. I'll bring him here, and I will bring him. You don't have to bother. He will tell you fantastic things about law and religion. He'll tell you fantastic things about law and morality. Because without morality, there can be no law. And the second person I must acknowledge for the inputs is a very young partner of a very old law firm based in Bombay. She has sent me a note on the future of legal education, which I'll give to the Chancellor because I don't have time to read it out. I'll give it to the Chancellor. Give me a day or two, I'll get it printed and send it to you. And you can circulate it to the students. Please read it. That is the future of the legal education. I thank the fraternity of Royal Global University for inviting me. It has been really a pleasure talking to you. And I hope and wish that all of you prosper. You are in the right place at the right time, doing the right thing, studying law. Please carry on, and I wish you the very best. Thank you. Jai Hind.